You can watch the seminar later if you'd like to, or share it with your colleagues, whatever it may be. It will be on the CTR website shortly. So welcome to the first seminar this year. For those of you who are new, assuming I can get my computer to work, which is not always a guarantee. I'm Ann Lavelle. I'm the compliance specialist for CTR. Prior to working with CTR, I practiced labor and employment law. I was a partner in a very large firm downtown for a couple of decades. I like to refer to myself as a recovering attorney now, but all I did was represent employer side, management side in companies when they had labor and employment problems, whether that was harassment and discrimination, union issues, or whatever it might be. So we're going to push forward here today. I always enjoyed doing training when I practice law, and I enjoy doing these seminars. As I say every time, if you have an idea for a future seminar, please let us know. Oftentimes the content of these seminars are based on the feedback that we get from you all so that we know what you're interested in. Okay, moving along. So we're going to talk about New Year's resolutions, checklists, and changes for employers. So we're going to talk about what is negotiable, what could possibly make you a progressive employer if you wanted to make certain changes, which might be helpful in today's labor market. And we'll also talk about what is not negotiable. And really, the new year is a good time to sort of look over some things and just say, do we have our ducks in order? And is there anything we need to update? So that's kind of what we'll talk about today. As with all of our seminars, I always start with what I call legislative update. Certain things that may be of interest to you that are happening either in Congress or in the courts or from a legislative standpoint. And so we have two kind of interesting things that are happening right now. One is a spending bill was just passed, and it has $25 million more for the National Labor Relations Board. And some of you may be rolling your eyes and saying, I don't care, that's for unions, if you know what the NLRB is for. Unfortunately, the NLRB is spreading its wings. Unfortunate for employers, maybe fortunate for employees, and saying, hey, we're looking at non-unionized employees too, and whether or not they're doing the right thing and allowing their employees to sort of gather and protect themselves. And the current administration, at least, supports that. And I try to stay apolitical in all these discussions, but the current administration supports the idea of unionizing and organized labor, which historically has been on the downslide, less enrollment, less membership. And now we're seeing a little bit of an uptick in unionizing. We're also seeing an uptick in strikes by non-union employers. And one of the more infamous ones, I guess, more famous ones, was the Red Cup Rebellion again this year by Starbucks. For those of you who didn't know what day it was, like myself, and drove through the drive-through and wondered why they were all sitting in lawn chairs, it's their way of protesting working conditions on a day that is historically a great sales day for Starbucks because they bring out their holiday cups that day. McDonald's, Taco Bell, Dollar General, all of them have seen similar organizing efforts. The $25 million is meant to support the NLRB as it looks at organizing efforts in unionized and non-unionized employers and how the employers treat the employees, whether you're engaging in any unfair labor practices when your employees collectively support each other. So just be aware that that's on the radar screen. And that is a priority that's now had substantial additional funding at the federal level. The other one that I'd like to point out, because this is just a hot topic all the way around. We talked about this a little bit at our last seminar in terms of cases of the year. And one of them involved a transgender case. We have another case now out of the state of Washington. It involves Alaska Airlines. And again, staying apolitical on this, I'm just presenting what has occurred here because you should know this is a trend. Most of the employment law trends start in the West because it's the most progressive area and move across the country. So what happened with Alaska Airlines is they had a uniform policy for any what they called forward-facing employees. In other words, employees that dealt with customers. And those employees could choose between a male or a female uniform. Now, importantly here, Alaska Airlines didn't care which uniform they chose, they just had to choose one. So if we use myself for an example, I am biologically female and I identify as female. I'm way too old to change. I'm past that 50-year-old mark. I could choose the male uniform if I wanted, but if I chose the male uniform, I had to abide by the restrictions on the male uniform. So I could be female and choose the male uniform, but I just had to pick one or the other. I couldn't mix and match. I couldn't one day say I want to be the male uniform and tomorrow say I want to be the female uniform. The main difference between the two uniform classifications was that the male uniform did not have skirts, and the female uniform was more generous in its rules regarding makeup and jewelry. So the male uniform, you really couldn't wear makeup, but for the female uniform, I could wear what they call tasteful makeup. I guess some mascara, lipstick, I don't know. I've never been into fashion, so whatever. In any event, one of their employees who identified as being gender fluid. So in other words, not really in one camp or the other in terms of male or female, sued the company in Washington State and said, hey, this is not fair. I want to mix and match these uniforms. Yes, I could be female and I can wear the male, or I can be male and wear the female uniform, but I can't mix and match depending on my fluidity. And the Washington State, their agency for discrimination, which is where these cases start, agreed with a gender fluid employee and said, hey, this is discrimination. If the person is fluid in how they identify in terms of gender, then you should allow the uniform choice to be fluid as well. And so if today I'm identifying as male, I can wear the pants. Now, as a female, I can wear pants too. That was part of the female uniform. And I can wear the male uniform today with no makeup and no jewelry or very little jewelry. And tomorrow I can wear the female uniform, or I perhaps can mix and match. Alaska Airlines has agreed to resolve the case with the Washington State Agency on Discrimination, and they are trying to craft a uniform policy that is acceptable to that agency as part of the settlement, but it's expected that it will allow some intermingling or changing of the uniform pieces and the accompanying makeup and jewelry and hair rules with respect to those uniforms. So again, you may all be saying, well, I'm not in Alaska and I'm not in Washington State, but this is a trend, right? We talked about it at the last seminar with the transgender cases and whether gender dysphoria was a disability. And we have courts saying, yes, it is. You need to give them time off if they have gender dysphoria. We now have a court saying, hey, if they're gender fluid, that's protected, and you need to rethink your dress code. As we sit here in Pennsylvania or Florida or wherever we are on the East Coast here, what I would suggest to you as you look at this case is to look at your uniform policy if you have one, and particularly, how do you allow people to choose what uniform? Do you have a policy that says, hey, females must wear blah, blah, blah? And if you do, how do you look at that in terms of if you have somebody who's transgender or gender fluid or has gender dysphoria, whatever it might be? And also rethink about the requirements of that uniform. You know, are you really going to say that the female uniform is the one that can wear earrings and necklaces, but not the male? And maybe the answer to that for your organization is yes, but you need to be aware that if you say yes to that, because that is your company culture and what you want to do, there's some risk and there's some pushback out there. And you may have to be in a position to defend that someday. Okay, as always too, I always invite questions. It's a much more interesting seminar or webinar. I wish it was a seminar, it's so much better in person. So please use the chat button or whatever and send any questions you have or any comments or feedback that you have as we go through here. All right, I always provide sort of an outline of our topics so that if you're watching this later, you can sort of fast forward to wherever you want to be. We're first going to start off with sort of a checklist for both employees and HR as to what you have to do and what is a good idea to do at the beginning of every year. We're then going to talk about rethinking employment practices. If you've heard the term progressive HR, we'll talk about that and what that means and sort of the reality of rules, right? Rules were meant to be broken, and employees prove that every day. We'll talk about what are the must-haves of rules and policies and what's nice versus necessary. Company culture plays a big part in that, and that's definitely changing in these difficult labor times. And then last but not least, we're going to sort of apply what we have talked about in terms of nice versus necessary and handbooks and rules and all that good stuff to real life employment case. And we'll talk about whether those rules helped us, whether that handbook helped us or hurt us in the litigation. So hopefully that will be interesting as well. All right, first let's talk about things we need to have our employees do. These are non-negotiable. You can be the most progressive employer in the world. You still have to do these. They don't come off the table because they're legally required. So every year you have to provide what I call EEOC training. EEOC is the Equal Employment Opportunity Commission. There's state and local agencies that are the equivalent of this. They all expect some type of yearly training with respect to anti-harassment and anti-discrimination with respect to your employees. And it's as simple as that. There is, if you get sued and you do not have this training in place or you only have it at the new hire stage, the EEOC is not going to be a happy camper with you. And that's not what you want to have happen. So let's talk about that a little bit. Harassment training, discrimination training, anti-harassment, anti-discrimination training can be anything you basically want it to be, and it depends on the size of your organization. It can be a video. It can be your HR person just talking to the employees at a lunch and learn. It can be bringing in someone to talk to them. The one pushback that I always got when I practiced was somebody would say, I do not want to do that because I don't want to know if there's a problem. I don't want to hear about it. That is really short-sighted. You are always better off to know if there's a problem brewing and have that problem brought to you rather than wait for that employee to explode and go to the EEOC. Much better to nip it in the bud. So one of the benefits, not one of the negatives of training, yearly training, is to feel the pulse of your organization. And if you see somebody taking copious notes during the training or asking a lot of questions, that should be a red flag that that person is bothered by something. And when I used to do this training for large companies, we would always look at who is like, writing the war and peace of notes while I'm talking, because that's a red flag. And again, much better to know if you have a red flag in your organization, because maybe you have liability and you don't know about it, you need to address it. I strongly, strongly, strongly recommend that you train your managers separate and apart from your employees, especially if you're a larger organization. Managers need to have a little bit of the fear of God put into them with respect to this. I've said this in other seminars, but it's often your frontline supervisors that cause you the biggest problems, often unintentionally. But they need to know that they have personal liability on the line if they do certain things. At the same time, we don't want to highlight that to the rank and file employee and be like, hey, your supervisor is personally liable if they do this. We do want to highlight it to the managers and say, hey, if you engage in XYZ conduct, which is illegal, not only does the company get sued, but you get sued too. And so even if you don't care about the company, think about your own personal assets and whether you would want to be sued. That is a wonderful reason to have separate manager versus employee training. Again, if you're really small, maybe under 10 employees, maybe that doesn't make sense to break it out that way. But if you're larger, it definitely does. Oftentimes, these trainings should be combined just because it's easier from a housekeeping perspective. with any other industry specific or OSHA training or anything else that you might have. Of course, you want them to sign off on the training. Any employee who attends training, you need some way to measure and have them sign off on it. And at the same time, you want them to acknowledge that you have anti-harassment, anti-discrimination, EEOC type policies that say, hey, we're going to protect individuals. You want that acknowledgement that they're aware of that. Other critical business policies can be signed off on at the same time. Okay, so somebody has a question here about EEOC posters. Let me get to that in a second as to where is the most reliable, best place to order them. So give me 1 second and I will get to that. One thing I'll say about any posters is always check the local regulations as well. Lots of federal posters do not include the local ones, and that's really common. So like in Pittsburgh, you have rules in Allegheny County and Pittsburgh about posting for their leave laws. That's not on the federal poster. So as we talk about posters, the EEOC updated their poster in October 2022. We've talked about that a couple of times at prior webinars, but just be aware that that's the case. Be aware that they update things from time to time, not just the EEOC, but the Department of Labor, OSHA, whoever, and you do need to keep current. The other thing you need to be thoughtful about is where is the poster located? It's supposed to be in a common location that's easily accessible to employees so employees can see it. Historically, this has been like the employee lunchroom or break room because presumably every employee is going in there and having lunch or eating or whatever. You now have a remote workforce thanks to COVID. So where do you put them? Obviously, you should have a landing site somewhere on your website that has these that would be accessible to your employees if you have remote workers who aren't routinely in the office or are out at remote locations somewhere. The other thing to, well, let me just jump ahead 1 second. So posters, I do have to give a plug here. So CTR has an e-update service that's relatively inexpensive. You can reach out to anyone at CTR, your CTR representative, and ask them about this. This keeps it automatically updated for you so that you know and get the updates and you're not left surprised if the EEOC updates something in October and you're more worried about your business, as you should be, than following along with the EEOC's minutia and little changes that they make to their poster. So that's one option. And obviously I think it's a good one since I work for CTR, but it's relatively inexpensive and saves you a headache because one of the things that happens with a discrimination or harassment suit is they ask about the posters. That's one of the questions. They ask about your policies. They ask about the posters. Where are they posted? Which version are you using? And, you know, have you updated them from time to time? And so if you have something like this, the answer is very easy. You can say yes. A lot of employers can't say yes to that. Even large employers, when I was practicing, a lot of employers were like, what do you mean the 5-in-1 or the 7-in-1? Those are names for the posters. So a cheap little bit of insurance, basically, to have the right poster is to subscribe to a poster service. Talk about benefits. So this is something that I see a lot of employers sort of falling short on. The law requires, so ERISA requires, and even if you're a nonprofit not covered by ERISA, you're still required to have health and welfare documentations like a summary plan description and a plan document. You should be having your employees sign off that they have it or have access to getting it if it's online or whatever it might be, because you really want to show that they had knowledge, they had availability to the plans, and they signed off that they did. So when we look at sort of our checklist, our must-haves for employees, and some industries like healthcare, childcare, you're going to have additional requirements because of the sensitive nature of your work and who you're working with and their vulnerabilities. But for your typical employer, this is sort of the must-haves from an employment standpoint. As we look in addition, so that's what we're going to go get the employees to do, is sign off on all that and make them watch the training or whatever it is. From an internal HR perspective, it's a good time to look at a few other things because the laws do change from year to year. And we want to be current. Wage and hour law. We did a couple of seminars that seemed to be hugely popular last year on the FLSA, the Fair Labor Standards Act, overtime, how you calculate it, who is or is not exempt. It's a good time to relook at that. What you see with wage and hour law is that the Department of Labor is sort of like a little pendulum. It swings back and forth depending on what administration is in power currently. And so right at the moment, we have an administration that is very supportive of rank and file employees and their rights to overtime, and takes a narrow view of how you classify people to be exempt. And so it's a good time to look at this and say, do we have folks rightly classified? You can go back and listen to some of our seminars. Paying a salary is not enough. So many employers just think paying a salary is, I'm good, the person's exempt. Not so much. They have to meet a duties test too. We have a whole webinar on that. Laws. So we've done seminars on these as well. But just briefly, we've got Allegheny County and Pittsburgh, if you're here in Pennsylvania. We have USERRA that's been updated. We talked about that at the last webinar as well, to expand the leave rights there. The FMLA, while that hasn't necessarily been modified from a regulation standpoint, you should always look at that and say, how does it compare to the other leave laws that I'm now obligated to abide by? And make sure you're running them all concurrently, because from an employment perspective, we are not looking to say, hey, first I'm going to run the Allegheny County leave, then the Pittsburgh leave, then FMLA. We want them to run concurrently. So you want to make sure your policies reflect that. Job descriptions, if you have them. Job descriptions are by no means required. They can be a good thing. They can sometimes be a bad thing too, because I have seen job descriptions that go on for 4 or 5 pages with essential functions, and I'm wondering who does this job? And we don't always follow what's in the job description, which is a problem. If we have something on paper, whether it's a policy or a job description, we will get ourselves into trouble as an employer if we're not following it. And so if it's out of date and you need to update it, you need to make sure, because you're going to use this as the basis for why somebody is classified as either exempt or non-exempt. Make sure that job description supports that. If you have Ann Lavelle running around as a laborer all day, but you have them exempt, it's not going to fly, because the piece of paper clearly establishes that I'm not exempt. Fair Credit Reporting Act. We have not done a seminar on this, but just briefly, if you're doing background checks, and some organizations are required to do these, you're checking to see whether or not Ann Lavelle has a criminal record, whether I was, had issues, anything like that, how my credit is, whatever it might be. You have affirmative steps that you must take to get an authorization from me before you run those checks. And then if you find out that I'm just a horrible person and I eat small children for dinner, and I have a criminal record that's a mile long and a credit history that shows, 10 bankruptcies or whatever, and you want to take an adverse employment action and not give me that job because whatever you found, there are additional hoops that you need to go through in terms of notice and giving me an opportunity to dispute that and say, hey, you have the wrong Ann Lavelle. That must be some other Ann Lavelle who lives somewhere else, whatever it is. So just be aware if you're doing background checks. Also, one of the biggest mistakes I saw employers make when they do these background checks is they would let the person start working, usually because they were desperate for employees, and then run the background check. And then they would find out something terrible about their employee and want to fire them. That puts you in a horrible position legally to do that. Do not let if you're requiring a background check, do not let the person start working until they have passed that background check. If it's important enough to do, it's important enough to wait until they pass that check, whatever your standard is, to let them start. Also be aware that the EEOC takes a dim view of firing people for criminal histories in most occupations, because their view is that criminal histories adversely affect minorities. And therefore, if you're using criminal histories as a guide to whether or not you'll employ somebody, unless you have a very good reason for doing that, then it's sort of a sign of discrimination. It has a disparate impact on minorities, so be careful of that. Job applications and offers, think about how that looks. Are you standardized? Are you using the little QR code now for them to scan it if you're a progressive employer and you're looking for new labor? So just think about that and how that looks. Utilization of non-competes, non-disclosure, non-solicitation. First of all, be aware that in most states, non-competes, including Pennsylvania, are disfavored. You can enforce them in certain instances. They're extremely expensive to enforce in terms of legal fees. But if you're going to use them, make sure they're narrowly tailored, make sure that you're using it across the board. So if Anne and her friend Joe are both in the same job, you can't just give the non-compete to Anne and not Joe. They will look at that, forget any potential discrimination issue that Anne's female and Joe's not. They'll look at that and say, hey, you don't have an interest to protect because Joe didn't sign it, only Anne did. And if you really wanted to protect your interests, whatever the non-compete, non-solicitation is, you would have had both of them sign it because they're in the same job classification. And of course, anti-harassment and discrimination training, you've got to do that. If your training is from a decade ago, if you're using some video that you got off the shelf 10 years ago, it is completely out to date. We've talked about gender fluidity, transgender, whatever. 10 years ago, that was not a subject in training videos. So if you're using a video, you need to make sure it's updated to reflect all of the various categories that are protected, not just what was protected 10 years ago, because that is fluid and that changes. All right, rethinking employment practices. If we want to be more of a progressive employer, we have a difficult labor market. We have the term work-life balance that has been thrown around for forever. And we have workforces that are looking for a value system, not just a paycheck. So let's talk about that a second. If you're looking to attract employees coming out of college, they are looking for causes. They're not looking for rules, they're looking for flexibility. An interesting commentary I saw by Jeff Bezos, who's Amazon, of course, or was Amazon. He said that the work-life balance is the wrong way to phrase this issue, that it presupposes it's a give or take. It's a choice. In other words, you can't have both. And so you may want to think about that the work-life balance may be the wrong way to frame this issue, that really we're talking about flexibility and a kinder, gentler employer maybe with less rules. And so as we think about that, let's talk about the reality of rules. So as I practiced for 20 some years, handbooks grew exponentially because every time there was a new legal theory, the plaintiff's bar would come through with some new legal theory, like the Alaska Airlines case, right? Now we have gender fluidity that we've got to protect. So should we redo our entire handbook to protect that? The answer was usually yes. Oh, yes, we need to update it. And you end up with handbooks that are War and Peace. I mean, they're huge, right? Nobody reads them. Nobody knows what's in them. But we just keep adding to them because we, as legal counselors, would try to protect the employer from every possible issue that could come up that we would want to say, yes, we knew about gender fluidity, so we addressed that in our handbook. And I'm not saying it's wrong to do that, but you do end up with like a rules of conduct list that's like 4 or 5 pages long if you're trying to address every single thing that an employer could do or an employee could do in your workplace that you would want to discipline or terminate them for. The other reality that I think is very true, and this percentage can vary depending on the industry you're in and the maturity of your employees, but really the rules are made for a small percentage of your workforce. It's sort of like the tail wagging the dog. You've got 5%, maybe 10% of your employees that are a huge problem, and you make the rules for them. because they are the ones that will push the envelope and try to weasel around whatever the rule is and find the loophole, whatever it might be. The other problem that you have when you have a handbook that is the size of, a dictionary is that it leads to inconsistent enforcement, right? Because nobody knows what's in it. That's always a problem. If you have a written document, and I don't care what it is, whether it's a policy, a handbook, a job description, and you don't follow it, and an employee can show that you don't follow it, that's a problem, because whether it's somebody like the EEOC or a court or whoever is going to say, hey, you had this in writing as a policy, and yet you're like out doing whatever. You look very inconsistent. You look like you don't know what you're doing. It puts you in a bad defensive position if you get sued. And so that's an issue with these handbooks that become so big that nobody knows what's in them. And you're really using it just so you can be a bit of a hammer on the 5%, 10% of your employees that are a problem. And again, the other reality is a very small percentage of these policies are actually legally required. When we look at what we have to have, and again, this can vary a little bit from state to state, city to city, industry to industry. If you're in healthcare, obviously you have additional responsibilities. You have to have anti-harassment, anti-discrimination. You have to have mandatory leave policies. You have to know the job classification. That doesn't necessarily mean you have to have a 5-page job description that lists essential functions, non-essential functions, education requirements, this, that, and the next thing. One of the pitfalls of large job descriptions, especially in a tight labor market, is we say we want X, Y, and Z as education and A, B, C as experience. And we ask for pie in the sky, basically, with these things. And when we have a tough labor market, we're not getting X, Y, Z, and A, B, C. So we hire the person anyway. What have we just done? Not followed our job description, right? I am not saying you throw out all your job descriptions. I am saying, first and foremost, make sure you've got the classification under the FLSA correct as to whether they're exempt or non-exempt. And then look at it and say, do I really need a 5-page job description? Yes, I'm trying to protect myself in case there's a discrimination, especially a disability discrimination lawsuit. But am I causing more problems and more potential harm to myself if I have everything in here and I'm really not following the education requirements or the experience requirements or anything else that might be in the job description? I really don't have Anne lifting 50-pound boxes, even though I put that down as an essential function. By the way, I'm way too old to lift 50-pound boxes. So you look at that. Think about your job description, whether it's actually reflective of what's going on. And then health and welfare. This is the piece that HR usually somehow misses. And when I practiced, I did a lot of ACA and HIPAA work. And those laws, along with ERISA, are very misunderstood. And what happens is employers don't have the documentation in place that they should have, or they think they have it because they have an insurance policy. Simply having an insurance policy or a member's booklet for your health plan falls far short of having the summary plan description and plan document that's legally required by ERISA. Those fines are out of sight if you get called on this by the Department of Labor's Health and Welfare Auditing sort of unit. You want to have that in place. You want to make sure it's updated. You want to make sure that you have the ACA and how you're counting employees, if you're doing that, in place, so that if you get called out, you can say, hey, here's my policy on how I count employees. Here's my SPD. Here's my plan document. And they should reflect what you're actually doing. You have to have those documents. It does not matter how big or small you are as an employer, which is unfortunate because these documents can be expensive sometimes. So you can be a company of 5 with a health plan. You have the same obligation as the Walmarts of the world to have a summary plan description and plan document. And these documents do tend to be very long, very tedious. Sometimes your broker can help you with these documents. and provide you with a template or something along those lines. Always read that template, know what's in it, make sure it comports with your policy. One of the benefit issues I saw repeatedly for employers is they would get the template, great. They would even fill in their name. Even better, they put the employer name in. They just didn't have insert name of employer. And believe me, I saw that too. And then the template would say employees are eligible for a healthcare plan if they work 20 hours a week. But in reality, what the employer was doing was you had to be full-time, 35 or 40 hours or whatever a week. So you had an inconsistency between the plan document and what the practice was. And usually in the plan document, that language about eligibility was buried somewhere on page like 50. So nobody had read it. And the problem then becomes is I, Ann Lavelle, only work, 20 hours a week. You told me I couldn't have healthcare insurance and that I wasn't eligible. And you only offer it to folks with 35 or more hours. And then I had some sort of terrible problem happen, whatever. And I start looking into things and lo and behold, the SPD or the plan document says, I'm eligible if I have 20 hours or more and you didn't offer me insurance. And guess what I do? Like any good employee, I sue, right? Or I file a complaint with the Department of Labor. Either way, you have a problem if you're inconsistent with that. So if you are getting a template from somewhere for the SPD or the plan document, please, especially on the eligibility criteria, make sure you're following it. On the claims review, same thing, because that can be the other point of contention. If your plan document says X, Y, and Z is going to happen with a denied claim, then yes, you better make sure you're doing that. Okay, so somebody asked, I'm so glad for this question. If you are under 50 employees, do you need to have an ACA SPD? So let me just clarify because I may not have said this very well. The SPD and plan document have nothing to do with the ACA. They are required by ERISA. The ACA is a separate policy if you're counting employees. But yes, if it doesn't matter employer size, how many employees you have. From an ERISA standpoint, if you're covered by ERISA, and most private employers are covered by ERISA, the exceptions to ERISA coverage are government units and employers like school districts or nonprofits. And those have separate rules that still have plan document requirements. You are required to have an SPD and a plan document. Again, if you're small, it may be a great option to see if your broker has a template for you for an SPD and a plan document. But please read that and make sure that whatever it says, because it is a template, is consistent with what you're actually doing. So just to recap here, because that's a great question. Thank you for asking it. ACA is separate from the ERISA requirement for SPD and plan document. Two different laws. There is no threshold to the number of employees you have to be required to have an SPD and plan document for your health plan and for your retirement plan, health and welfare. So you need it for both of them. Oftentimes on the retirement end, you are getting assistance from a broker with that, but you need to make sure you've got that. A member booklet, Highmark's member booklet, UPMC's member booklet is not a summary plan description. It's not the plan document either. So just because they give you a nice thick booklet doesn't mean you have protected yourself from an ERISA problem, which again comes with just ridiculous fines. I mean, these fines, it depends on what the violation is, but it can be like $1,100 per violation per day. You don't want that. Typically, you can negotiate those down, but nonetheless, that's not where you want to be. Okay, I hope that answered the question. Thank you for the question. All right, moving along here. So nice versus necessary. What we just talked about is what is necessary, including some documents that are usually forgotten in the health and welfare realm of things. But let's talk about if you want to be a progressive employer, because you need to attract employees, or maybe it resonates with you on just a cultural level that that's what you want to do. So the first thing that I would say is, even if you wanted to be the most rule-oriented employer out there, and you want that handbook that is the size of the dictionary, you can do everything right. You're only going to do it 99.9% right because nobody's perfect. You still get sued. That is just the reality of our legal system, is that you can do everything right. Our legal system allows lawsuits and very, very, very rarely finds that those lawsuits are frivolous. I've heard before from clients who've said, hey, well, if I get sued as a frivolous lawsuit, I'm going to sue them back for being frivolous. It doesn't work that way. And so whether you want to be the most rule-oriented employer in the world and run a tight ship and you're going to comply with the law because that's ethically the good thing to do and it's what you want to do, it doesn't keep you from being sued. You can also run the loosest ship in the world. You get sued too. Get employment practices liability insurance. I sound like a broken record in every webinar with this. It allows you to make employment decisions without being handcuffed that you're afraid you're going to get sued and that the liability is sort of like the sky is the limit. EPLI, employment liability practices liability insurance. You know your liability is your deductible and the headache of a lawsuit. It's no fun, but it's not a bet the farm situation. So please consider that, no matter whether you want to be progressive or rule-oriented. So, when you look at this, you say, what's our culture? And so I love these two quotes, right? One is from Steve Jobs from Apple, who said, if you want to make everyone happy, don't be a leader, sell ice cream. And then we have the CEO of Bunnings, which Bunnings is like the Home Depot of Australia. And he believes in the 4 H's of leadership: honesty, humility, helpful, and happy. And when you look at that, you may say, well, just based on their sort of company statement there, right, by their CEOs, you might feel that one culture is more friendly and better, whatever. Or maybe you say, gosh, that's pie in the sky and that's not how the real world works. And, Steve's got it right. Either way, that's your decision to make in terms of your culture. But when we look at what's nice in handbooks or policies, but isn't actually necessary, rules of conduct, right? There's no law that says we have to have a rules of conduct section. And those sections have grown astronomically in terms of length to cover every possible rule that's out there. I mean, do I really have to say you can't murder your coworker? And yet that's in some rules of conduct. That would seem like common sense. Sometimes you can just have a blanket statement that says, we expect you to behave appropriately, and we're the judge of whether that is appropriate or not. That way you don't run into a problem where you have, if you do this, this, and this, we're going to discipline. And then when that happens, we don't discipline because Anne's our best employee and we don't want to discipline her. We can have this be more fluid. Dress code. We certainly should look at that in terms of the Alaska Airlines case. But again, dress code's not required at all. That's a choice. Attendance. In theory, we don't need an attendance policy. I certainly think those are nice and helpful, especially in some industries, but we can have an extremely flexible attendance policy. Same thing with vacation, internet, and email. Certainly, we should be saying these are our technologies and don't abuse them. But whether or not we need a 10-page internet and email policy is a different story. Reference checks, maybe yes, maybe no. They're mandatory in some industries. Job application, sure, use the QR code if you want. That is really up to you. But these are all things that are on the table for discussion as to what we want to do. So when we talk about company culture, and one of the things I want to point out, if you're unionized, all those things that we just talked about, they're probably the subject of bargaining. So if you're unionized, you're in a different situation than most folks. So where do you want to position yourself? If we can believe the research on this, employees want causes, not just profits. They want flexibility. They're looking for tuition help. They're looking for parental leave, daycare, conducting stay interviews. I actually think that's a great idea. I heard somebody call this CYA squared. I thought that was a great term because it stands for what you think it stands for. And it also stands for care for your associates. So CYA squared, right? We're going to protect the employer, but we're also going to be considerate of our workforce. We're not going to be draconian in our approach to things. Social media presence and connections, that was not present, 30 years ago when I was getting out of law school and looking for a job. But they're, employees are looking at that as to the company's social media presence and connections and how they position themselves. Are you cross-training your employees? Is there transparency in the workplace? Are you going to list what everybody makes? There's pluses and negatives to that. Are you changing from the typical pyramid of the org chart to more of a teams or bubble approach? So those are things that progressive employers are doing. And where do you get the hiring pool from? Do you start earlier? High school? Very interestingly, I've seen a lot of companies that are now doing or allowing high school field trips because they're trying to say, hey, look at our industry. We're great. And we recognize that you may not be in a position to join our company for 5 or 6 years. But think about us, right? We're trying to recruit early. We've got internships, paid and unpaid. We're looking not just at college, but at high school folks to say, hey, where do we build these relationships earlier so we can get a pipeline of employees into our workforce? All right, let's talk about real life for a second, because a lot of this is theoretical and it really is dependent on your culture as to what you want to do. There's no right or wrong answer. But let's talk about how this plays out. So we have a handbook, as most companies do, that says a no call, no show equals 2 attendance points. So they have a policy that says a certain number of call-offs or call in late to call off, whatever, you get a certain number of attendance points. It's a very common type of policy. Progressive discipline is implemented based on the number of points. So if I just have 1 point because I showed up 15 minutes late to work, I get a verbal warning and don't show up late again, right? We document verbal warnings in the personnel file. With 2 points, I get a written warning, 3 points of suspension, 4 points of termination. We're looking at a rolling 12-month period for attendance. So we have that in our handbook. That's not a bad policy. Even with a policy like that, we would always be cognizant of the FMLA and the ADA absences because we cannot assess attendance points for those types of issues. So be cautious if you have a no-fault attendance policy with attendance points. But we've got Angelica. She's a 20-year employee. She's great attendance record, great employee. Labor, she misreads the schedule. I have misread schedules, right? We all have. And doesn't show up. She's a no-call, no-show. But she's been there 20 years. She's a great employee. The supervisor, again, your frontline supervisors who inadvertently cause problems for you, doesn't give her any problem and tells her not to worry. Stuff happens. He actually uses a different word, but this is a family program. It's a tough labor market. He doesn't want to upset her, right? It's a tough labor market. He doesn't want to lose somebody who's great. And really, he understands because stuff does happen. It was an innocent mistake. At the same factory, we've got Joe, who's a 2-year employee. He's also a laborer. What does that mean? He's in the same job classification as Angela. You treat folks in the same job classification the same, or else you have issues. You treat similarly situated employees the same. He's contentious. He is a little bump in the road at your workplace. I'm sure none of you have little hiccups at the workplace, but it happens. Maybe he's silently quitting. Maybe he doesn't care. Maybe he's from that younger generation that just doesn't value work. It's a sunny, beautiful day, a few months after Angelica made her mistake. He's a no-call, no-show. He's probably out golfing or whatever it is he likes to do. He is at the point in the attendance system where he is terminated because he is not a good employee. He's had prior problems. Like all good employees, he turns around and sues us. What does he sue us for? This is where I wish this was a seminar and we could chat about this. He sues us for reverse gender discrimination, right? If they had been different races, he could also sue for that. Different ethnicities, he could sue for that. But it doesn't matter that he's a white male and Angelica is a white female. It doesn't matter that historically men have not been discriminated against. He turns around and says, it's reverse gender discrimination. You didn't follow your handbook, number one. And number two, I have a comparator in my lawsuit, a comparator who is in the same job classification, who is similarly situated, and you didn't discipline her at all. You didn't give her that written warning. You didn't give her the points when she made that innocent mistake and misread the schedule. Does the handbook save the day? Does it ruin the day? It sure doesn't help us, right? If we had been consistent, the handbook would not ruin the day. From the standpoint of defending Joe's lawsuit, it might ruin the day from the standpoint of Angelica. If we had disciplined her, she might have walked off the job and said, gosh, 20 years of service, I make one mistake and this is what you do, right? Like, we could have lost a valuable employee. Our handbook could have ruined that day. The handbook is kind of ruining the lawsuit day because we have something written that we didn't follow. We have inconsistency here. And so our best defense to this is going to be to try to argue that they're not similarly situated, even though they're in the same job classification. And we're going to have to try to make some argument that, well, hey, Angelica is a 20-year employee and we've never had a problem with her. She has no prior discipline. Her halo is polished. But that's not what our handbook says. Our handbook does not say, if you're a 20-year employee, we give you a free pass, right? Or if you're a 10-year employee and make one mistake, we give you a free pass. That's not what it says. You have a defensive problem here. If I was defending this lawsuit, we would be talking about settlement because we will never, ever get a court to just toss the lawsuit because we have a factual dispute here as to how we handled the handbook policy and the consistent or inconsistent application of that to two different genders in the same job classification. What if we didn't have a handbook? What if we didn't have an attendance policy here? Will we be any better off? Well, Joe would then still be saying we treated her probably better than him. We would again be saying, you're different though, right? You've been a problem child for us since day one. And you're not this similarly situated. You don't have the tenure that Angelica has. The benefit would be, we don't have anything in writing that says we violated our own policy, and that would be helpful. So I use this example, which is kind of a common example. You can change the names and the type of violation. It can be dress code. It can be swearing in the workplace or whatever. Frequently, we don't follow our own handbook, and that causes problems if somebody turns around and sues us because we make judgment calls that are probably good judgment calls based on the quality of the employee that we are dealing with. And so I would encourage you to look at your handbook in terms of flexibility so that you can say, gosh, I have some flexibility built into my handbook or my rule policy or whatever it is that allows me to make a little bit of a better argument than when I treat somebody maybe inconsistently. I can make an argument to say, well, gosh, it's not a straight out violation of my handbook policy. I have flexibility in my policy, right? Maybe I write into my attendance policy, each case will be considered on its own merits, right? And we will accept certain excuses, perhaps, whatever it might be. Maybe look at that and say, I need more flexibility rather than this dictionary size handbook. It makes me look not progressive. It makes me look a little draconian. And from a defensive standpoint, I'm going to trip myself up because I am not going to follow it and I'm going to look inconsistent. And that's one of the worst spots you can be in defensively. Okay. That is the end of the seminar. I appreciate everybody attending. Hopefully that gives you some food for thought of what you need to do for the start of the new year and, how different scenarios can play out depending on your culture and the rules and policies you want to have in place. Next month, because it's Valentine's Day, we're going to talk about relationships. I don't just mean consensual romantic relationships. We're going to look at it more broadly than that. If anybody has any questions or anything, please let me know. If you have other ideas for the seminar, let me know that as well. Otherwise, hope everybody has a good afternoon, even though it's raining here in Pittsburgh. Take care, everyone. Oh, there's one question. Let me see if I can grab this real quick. Oh, you are quite welcome. Happy to do the seminars. I love doing these. Hopefully someday we can do them in person. I think that would be a great option. All right, everybody, take care. Have a good day.